Or classes. My name is Tamara Piety, and I'm the Associate Dean for Faculty Development at the University of Tulsa College of Law. And I want to welcome you here to the last Faculty and Alumni Showcase series of this semester, and probably the most exciting that we have had. This time we have not one, but two speakers. First of all, our beloved and well-known Professor Ray Yasser, the Duke, well-beloved, a graduate of Duke University and a longtime professor at the University of Tulsa, the author of Sports Law, Cases and Materials, which is one of the premier books in the field, and also who has been a warrior for Title IX litigation, along with our second speaker, alumnus YasserHanlon, who's received his degree from University of Tulsa in 2006. He is currently working in construction and real estate litigation at Holland and Hart in Denver, Colorado, but he, prior to coming to law school, part of his interest or his career that led to some of this interest was he was a Division I basketball player at Northwestern prior to his law school career. So he brings to this that interest as well. And we're really excited to have him back to give this talk. And with that, welcome.
Thank you. Welcome. And I need to preface her comment that I played basketball a long time ago. And she did mention I practice construction and real estate litigation in Denver. She didn't mention that I'm a sports law practitioner, because I'm not. And I suspect that there's not any sports law practitioners in this room. If there is, maybe we can switch spots and I can eat some lunch. But I wanted to talk to you a little bit about full disclosure. I've got this black eye, and you notice it's on the left side. Professor Yasser is a left-handed person, and we were arguing about who's going to go first. And the truth of the matter is, I play in a Denver Lawyers football league and caught the business end of an elbow 2 weeks ago, and I was hoping I wouldn't have this today, but I do. So the birth of this idea: does the NCAA exploit college athletes? The spring semester 2006, I was taking Professor Yasser's advanced torts class, and he was talking about appropriation and how you take someone's name or likeness for your commercial advantage. And I remember Professor Yasser speaking about the likeness part of that. And I was listening very intently to your class, as I always did. And he talked about there are instances where it's not the name that's appropriated or the actual photograph that's appropriated, but the likeness or the identity. And there were some examples about what constitutes someone's identity. Immediately popped into my little brain was Kendall Gill. Kendall Gill played basketball for the University of Illinois. I'll talk more about him later. But I had to get his jersey when I was a kid. And NCAA rules prohibit the use of names on the back of jerseys. But I knew exactly who number 13 was, and I didn't want any other number. So that idea was kind of born during that class. Talked to Professor Yasser about it later, and from that idea we developed this law review article that's, I think, part of your materials today. So I want us all to take a break from our lives and enter this sports law realm where sports and the law intersect. It's kind of a fun place to be for 50 minutes or an hour. So the NCAA has rules. They have lots of rules, bylaws, and they have a constitution. In Article 2 of their constitution, they have 16 foundational principles. And in order to pass any legislation, that legislation has to be in furtherance of at least one of the 16 principles in Article 2. For the purposes of this discussion, there's really three principles that are relevant, I think. One is the principle of student-athlete welfare or well-being. One is eligibility. And then this one is of primary importance. The NCAA, as part of their foundational principle says that student athletes should be protected from exploitation by professional and commercial enterprises. But rather than protecting student athletes from this exploitation, it's my view that the NCAA and its member institutions and official licensees actively participate in the exploitation. Over the years, the NCAA has endured criticism relating to its contradictory mission. On the one hand, they strive to preserve student-athlete welfare, principle of amateurism. On the other hand, they're trying to get as much money as possible for their member institutions. And we all try to make money, and that's natural. But by reaching and trying to grab for more money, all of a sudden the student-athlete welfare and the principle of amateurism kind of blurs over time. And it's also my view that the student-athlete is the one that doesn't benefit from that. College sports is a big business. It's a multi-billion-dollar business. The collegiate licensing industry has brought in the following revenue. And what's interesting about this, so in 1984 they bring in about $250 million, and this is sports merchandise. Between 84 and 85 it jumps up to $1 billion, and that's, you might not be able to see that that's a B over there, not an M. And Kendall Gill's jersey, that was 1988. And just from my experience, I don't know if this is entirely true, but it seemed like the popularity of replica and authentic jerseys became really big in the late 80s and then has skyrocketed since then. It's star personas, star player jersey numbers in the professional ranks and in the collegiate ranks. So in between 1989 and 1993, if you remember the University of Michigan, the Fab Five, I remember seeing jerseys, Jalen Rose, Chris Webber jerseys all over the place. So that was the 1993-94 season. When Professor Yasser and I wrote this article in 2006, it was $3 billion. And in 2008, when the article went to print, we checked again, it was still about a $3 billion annual revenue. And interestingly enough, I checked last week just before this presentation just to see if it had changed, and it's up to $4 billion annually now just in the past 2 years. By the way, there's over 2,500 companies officially licensed to produce college sports merchandise. And what's significant about that is, of those 2,500 companies that sell those products, every single product that's sold, when that product, if that product's represented by a university, every university gets a royalty for every product that's sold. So this generates lots and lots of money, and schools get plenty of toys to play with because of this. And this is an example. I know we're in Oklahoma, so there might be some folks that loathe the University of Texas, but the Godzillatron, when they bought that, it was the largest high-definition video display in the world. It might still be, for all I know, but it measures 145 feet diagonally. And this came about after the 2005-2006 academic year when the University of Texas won the college football championship. That year, they shattered the previous merchandising royalty record by over $2 million and brought in $8.2 million just in merchandising royalties. The record, by the way, that they shattered was the 1993-94 University of Michigan record of $6 million. In the 2009-2010 academic year, University of Texas brought in $10.1 million just in merchandising royalties. So this is a huge industry. Now, University of Texas did not make $10.1 million in merchandising royalties selling T-shirts that say University of Texas and coffee mugs that say Longhorns and pencils. What the NCAA member institutions are figuring out, and have figured out since at least the 80s, is that there's a value to star personas' identities, and they can capitalize on that value. They put a star player's jersey number for sale, that goes off the shelves very quickly. And EA Sports, of course, does a fantastic job putting together video games that depict not just the jersey numbers of actual student athletes, but depicts things such as skin tone, hairline, what you wear as an athlete. I mean, down to the very detail where your hometown was. All of this is depicted in the video games. So there's no mistake, there's no coincidence that these top-selling items that are driven on star personas' identities are being capitalized on by the NCAA schools and their official licensees. So back to the Kendall Gill idea. So I grew up in Illinois, and my whole family are huge Fighting Illini fans. And I was about in fifth or sixth grade or so, and I was at my grandfather's house with my dad on Saturday watching University of Illinois play, and it might have been this exact play. Probably not, but let's just pretend it. Kendall Gill steals the ball, goes the whole length of the court, flushes the ball. Orange Crush goes crazy. The Illinois faithful go crazy. I go crazy. They break to a commercial, and I say, "Dad, I need a Kendall Gill jersey." My dad, typical, looks at my grandfather, rolls his eyes, looks back at me. I'm anticipating a lecture. "Okay, what, Dad?" There's a difference between needing and wanting. And I said, "Okay, I want a Kendall Gill jersey." "You win." "Okay, so you want a Kendall Gill jersey. That means you need money. Okay? And if you need money, I suggest, it sounds to me like you need to shovel some snow." So I wanted that jersey, shoveled my grandfather's snow, shoveled my parents' snow, went to the neighbor's house, and earned enough money to buy a Kendall Gill jersey. And when I put that jersey on, it felt like $2 million. And had my grandfather bought me a number 55, or suggested that I get 55, I wouldn't have shoveled a single ounce, one snowflake. I mean, I needed this jersey. It didn't have his name on it, but I wanted Kendall Gill's jersey. 88-89 season was the Flying Illini with Marcus Liberty, Nick Anderson, Kenny Battle, Kendall Gill. And it was his identity that I wanted to wear. So the jersey number is very much a part of a person's identity or their likeness when you're talking about sports. Star players' numbers are inseparably linked to their identities. Oftentimes, not oftentimes, but people retire star players' jersey numbers so that no one else can ever wear that jersey number. So there's no doubt about placing a star player's number on a product enhances its value. It immediately increases the popularity, and the price goes up. And then people start shoveling snow just to buy it. So this is kind of a recap of what I just kind of went through. College sports merchandise is tailored to capitalize on this market, but the NCAA prohibits the students from reaping any benefit from it under the guise of preserving amateurism. And so the question for you is this appropriate or is this appropriation? I think you know where I stand on that topic. So when Professor Yasser and I developed this article, we wanted to create a fictitious student athlete that readers could just insert their favorite star college player into the discussion, and it would most likely apply. So we developed this J.J. Morrison character, which was based, at the time, the two top college basketball players were Adam Morrison from Gonzaga and J.J. Redick from Duke. But the interesting character is Adam Morrison. Not just because of his unique style, but because he played at Gonzaga, and before he arrived on campus, Gonzaga had many diehards, people that lived in the area, people that went to the school, their students, but it was really kind of a local market. After he arrived on the scene, and he was kind of a bit of a surprise. He wasn't, relatively speaking, highly recruited. and he became the best player in the country. And because of his unique style and his playing abilities, he developed just a national notoriety instantly. And it's with technology today, the world is a smaller place, and by virtue of the technology, it makes the market just expand. So there was an article written about him achieving rock star status, and it was really true. Gonzaga, after Adam Morrison, has 100 manufacturers manufacturing Gonzaga merchandise. Now, the director of Gonzaga's campus stores, collegiate licensing, and online sales was quoted as recognizing that online sales increased 400%, and he attributes that really to Adam Morrison. The interest in Adam Morrison put Gonzaga merchandise on the map throughout the country. And so, and in fact, he also said, anything we put a number 3 on would sell. He's just hugely popular. And because of his popularity, he was picked to be the face of the video game, the 1990s, 2007 EA Sports March Madness game. So I'm going to talk about just a couple other examples. Rudy Gay, while he was currently a player at UConn, an official licensee of Husky wear put this quote underneath his jersey. NCAA rules prohibit the use of a player's name, but we all know who wears this one. Then you've got Derek Ravio, who was an excellent player also for Gonzaga. This official licensee went so far as to put a picture of his jersey and right above it put Derek Ravio jersey. And it's just a blatant appropriation of Derek Ravio's name and likeness. And also beneath that quote it says, support your favorite Gonzaga basketball player with this handsome replica jersey. Now support must mean some moral or emotional sense, but Derek Ravio got no money from that. And before this presentation, I went online and looked at who the preseason All-Americans were. And if you guys have some time to kill later, just search for a preseason All-American's name and jersey, and you'll find some scenarios just like this. Check Singler for Duke, especially. Find some gems. So, the video game industry, extremely popular and extremely amazing. You'll notice that NCAA football 2011 and NCAA basketball 2010, EA Sports decided to discontinue its basketball version for 2011, and some articles that I read speculate that it's based on, there's a couple class action lawsuits currently pending on this very issue. Sam Keller was a quarterback for Nebraska. He's the named plaintiff in a class action lawsuit against the NCAA and EA Sports. And Ed O'Bannon, who played basketball for UCLA in 1995, was playing this game and realized when he clicks on the 1995 UCLA team, there I am. That's my hairline. That's how I wore my shorts. And so he has now initiated a lawsuit, a class action lawsuit. And why would they discontinue basketball and not football? I don't really know, but obviously with basketball, the image, you're seeing much more of the person than in the football game. EA Sports, by the way, is the collegiate licensing company's largest licensee. And some schools, some of the more predominant sports schools, get six-figure paydays from EA Sports. And EA Sports makes millions of dollars just on its football game alone. So, you guys think that's Blake Griffin guarded by Cole Aldrich? There's no name there. But just look at Blake Griffin's face. For any of you that have watched Blake Griffin play, it's unmistakable. Hairline is correct, his skin tone, body composition. Same with Cole Aldrich, except his hair is a little shorter. And there's no mistaking. And that guy on the Memphis team, that was me 2 weeks ago in my flag football. And I also want to point out the detail here in the stands. And see this girl over here? She's thinking, how are they getting away with this? I also want to point out the difference between the NCAA video games and the professional ranks. Professional games, they include the athletes' names, but the athletes are compensated, and compensated pretty handsomely, might add. So EA Sports has a well-publicized slogan, "It's in the game." If you watch a commercial featuring and promoting their game, that's what it ends with usually. It's in the game. So this is derived from the idea that whatever is in the real-life arena is brought into the game, and I would say that's true. If you buy this video game, you're participating in the exploitation of NCAA student athletes. Got a little promotional video to show you from EA Sports 2010 version. Now this is from the season, the 2009-2010 academic year. And I want you to notice as I play this video that they flash frame and kind of freeze on certain players. And those players are very recognizable. And that's by design. If this is too loud, I apologize. Sharon Collins, Kaylin Lucas.
Amazing.
Yeah, I'm done. And this ends on an image that I want to talk about. So this is Sharon Collins and Lance Teeter from Kansas and Nebraska. And you'll see that Lance Teeter has his socks kind of come up to about his calf or so. He's wearing Adidas. Sharon Collins has the Adidas logo on his shorts, wearing Adidas shoes, has the arm warmer on his left arm. Long socks, skin tones are different, facial structures are different, hairline's different. Oops. And so here's a couple images of Sharon Collins, or an image of Sharon and an image of Lance. And you see the socks are similar. They've got their Adidas shoes on, arm warmer on the left arm, skin tone is different and represented. So there can be no mistake that these are the players' virtual likenesses. And I'm not saying that EA Sports should discontinue its games because they're fun to play, but I think the student athletes should be compensated in some way.
So that was kind of the facts. You can be my video guy. We decided to divide this up where Sean would kind of like the factual presentation, and I would do a quick look at the law as it applies to this fact scenario. And it's nice to see everybody here. I see a lot of old friends, and I hope I have some time afterwards to visit with some people I haven't seen in a long time. That's always a lot of fun. But, it strikes me, we had this backdoor play where he's going to, I used to do this with my son when we played pickup basketball. It's a backdoor play. So for Sean, that's an indicator to go to the next slide. To me, it's kind of a straightforward, what does the law say? I tend to look at things through a legal lens, and it strikes me as fairly straightforward. The restatement of torts says one who appropriates to his own use or benefit the name or likeness of another is subject to liability. So it's kind of straightforward. It didn't strike me as particularly difficult. The case law varies. Some of the courts treat this as an intellectual property case, and intellectual property is kind of a daunting term. If you're out there practicing law, it kind of carries a certain cachet if you say, well, I practice intellectual property law. But really, it's just a form of property that's intangible, something that you can't really hold and take with you, but nonetheless, it's a protected piece of property in the eyes of the law. Some courts call these kinds of cases right to publicity cases, because for the most part, people whose name or likeness have commercial value are celebrities, artists, and the like, and it's really the right to publicity that they're complaining about that's being stolen from them in a way. Most of us really don't have much commercial value in our name or likeness, although I have always thought there's an untapped market for bobblehead law professor dolls. And I see that some of my students out there, I think it would be really helpful around finals as you're studying for the torts final to have bobblehead Ray over there and you can kind of vent your anger. But nobody's taken up that marketing. Most of us don't really have there's really not commercial value in our name or likeness. But the starting point here is simply ask linguistically, has the NCAA appropriated to their own use the name or likeness of college athletes? And it strikes me as no doubt about it. I mean, it's kind of an easy call. In property law, we would call someone who takes someone else's intellectual property a pirate, which is a nice, quaint term. So the NCAA, it strikes me, is acting like a pirate, an intellectual property pirate, taking property that rightfully doesn't belong to them. And the fact that they obscure what they're doing by not putting the name of the player on the back of the jersey, for example, strikes me as pathetic. I mean, we know what they're doing. We know people in the know whose name or likeness is depicted. And the fact that they don't use the name or likeness of the player doesn't obscure the fact that they're taking the name or likeness of that player. I tried to come up with an appropriate metaphor, and I'm not sure that this is entirely apt, but it strikes me that it's kind of like, taking a stolen car to a chop shop, having carved off the ID number from the car and removed the license plate, and claiming that the car is now yours because the car doesn't have an ID number and a license plate. I mean, it's clear theft is what the NCAA is engaging in, clear and simple. Now, for this tort, there are some defenses that are available. So the case isn't over. This is kind of the plaintiff's prima facie case. And there are ways then in tort law, you remember that the plaintiff makes out the prima facie case, the defendant pleads by way of justification, hey, I should get off the hook. There's some explanation for what I'm doing. So I don't think the case is quite over. The NCAA would have the opportunity to justify in some way what it is that they're doing. So for example, this is a portrait of Tiger Woods, an artistic, it's not a great reproduction, but it was done by an artist who sold limited edition Tiger Woods paintings. And the Tiger Woods lawyers sued him on appropriation theory, saying that you were cashing in on Tiger Woods' name or likeness through this art that you had produced. And the court, in the Tiger Woods case, said, well, that's protected. This is not so clearly a taking of a name or likeness without justification. there was some artistic creation. You know, you had transformed the tiger likeness into something of your own. And there's kind of a privilege lurking there for an artist who creates a new product. So Tiger loses that case on the theory that this creator is not really a free rider in the sense of cashing in on Tiger's name or likeness without doing any work themselves. And so the artist is protected and Tiger Woods loses. So it's kind of an artistic creation privilege-like defense for appropriating name or likeness. Another example, this is iconic, so I'm old now, and I remember this clearly when Joe Namath had guaranteed a victory in the Super Bowl when the fledgling AFL was challenging the NFL supremacy, and Joe Namath, who was a sexy guy, it's hard to compare him with any modern-day athlete now. I'm trying to think of some modern equivalent to Broadway Joe. But Broadway Joe had guaranteed that the Jets would indeed beat the Colts, which they did. And he was featured on the cover of Sports Illustrated, which was then used in an advertising campaign by Sports Illustrated to sell subscriptions to Sports Illustrated. And Namath also lost. He sued Sports Illustrated, saying, you're exploiting my name or likeness for your commercial benefit. And he lost on the theory that it was newsworthy. So there is, in fact, lurking behind this towards some kind of newsworthiness defense. And it strikes you as kind of obvious, you think about it, that a celebrity can't entirely own their name or likeness and prevent news accounts from appearing about them. So there's a newsworthiness privilege lurking there. But I guess I would ask you, is that pertinent to what the NCAA has done? I mean, has the NCAA really created some new product? Do they enjoy some kind of newsworthiness defense? I don't think so. So what it comes down to in the end is the NCAA ends up arguing that they defend themselves by saying that college athletes, by signing a grant in aid or a scholarship agreement, consent to the NCAA's use of their name or likeness. That implicit in agreeing to a scholarship, you're agreeing to allow the NCAA to use your name or likeness for their commercial advantage. That the NCAA, in essence, is protecting you from commercial exploitation by exploiting you themselves. But the NCAA is actually arguing this in litigation, that there's a their legal defense is consent. And in tort law, you may remember this from torts, running through all of tort law is this notion of consent. It harkens back to Latin law, the Latin phrase being volenti non fit injuria, to a volunteer no wrong is done. It hides behind the name of assumption of risk in negligence cases, consent, the notion being if you're agreeing to let this happen to you, you're kind of an unworthy plaintiff. So the NCAA is actually arguing this, that college athletes have agreed to let this happen to them. They've consented to it. So I started to look through, and Sean and I, in doing this article, said, where are they getting this from, this notion of consent, which is going to be their primary defense in the case, the notion of volenti non fit injuria. And so, can it be fairly said that college athletes, when they sign a scholarship agreement, consent to the use of their name or likeness and the commercial exploitation of them by other people? And so I looked at it, and I just recently, in fact, in anticipation to this, contacted the NCAA for the most recent version of their handy, small telephone book size Division I manual, which I paid $25 for, which is ridiculously overpriced because they also only sent me the most recent published edition, which was 2007. And presumably the consent that the athletes have manifested is in here somewhere. See, because what the NCAA says is when you sign your scholarship agreement or your grant and aid, it incorporates by reference. This is something lawyers often do. Instead of printing the whole damn thing, they say we incorporate by reference some other document. So they incorporate by reference the Constitution and operating bylaws. And so when you sign your letter of agreement, you say, and I understand that I'm abiding by all the rules contained in this document that's incorporated by reference. So the NCAA is arguing that consent is somehow contained in the document that these athletes are signing. And there are a number of problems with that, one of which, probably the primary one, is I'll be damned if I can find it. I mean, in fact, I'll now issue a public challenge to anybody who will take me up on it to give you a prize of, at this point, unknown value if you can find where consent is. I did go through it, and we did go through it in preparing the article. And what you have are a very complicated set of rules dealing with amateurism that really vary very much from sport to sport, which primarily bind the parties to this agreement. And the parties to this agreement are NCAA member schools. And in fact, if anything, what this reveals is that the NCAA member schools are violating their own agreement in which they say they won't commercially exploit athletes. But believe me, and again, I will issue the challenge if anybody wants to, you can't find any notion within this incorporated document that college athletes agree to allow the NCAA to commercially exploit their name or likeness. And so it just strikes me as preposterous that they would make this consent argument, which apparently they're relying very much upon in defense of this lawsuit. So, again, I look through it, I guess back to the, this is what it comes down to me. I kind of teach law definitionally, and a tort is a tort. This is a pretty easy one. Strikes me very clear that the NCAA has commercially appropriated the names and likeness of college athletes. And we like to think there's a cause and effect with our article, because we were talking about this the other day. You like to believe you make a difference in the world, and you don't really know if you do or you don't. But we think that somebody picked up on the article and then did the lawsuit. Now, I wish I had had a plaintiff, because I think the lawsuit's got tremendous value. Because what did we say? We published this in 2000.
Winter of 08.
And then the lawsuits came out
in 2009.
2009. So it strikes me as a pretty decent lawsuit. Now, so the question is, what's the remedy going to be? And that would be a natural one to ask. And what does this all mean? Where's it all going? If in fact there's been an appropriation of a name or likeness, then the NCAA has been somehow unjustly enriched, and they need to disgorge their profits. And the money that they've made in this theft, this piracy, needs to be returned to its rightful owners. Well, that raises some administrative problems, because, and this is something nobody's fully thought through. I think the lawyers know, we're bringing the class action lawsuit, that at least some of the money will go to them. that they'll get. They're probably on a contingency fee. But then the equitable problem becomes, well, what do you do with the rest of that money? And there are a number of ways to resolve that, I think, that make sense equitably if we're in a court of equity ultimately determining what to do with the money. You can set up a trust fund to be administered, particularly in the service of this athlete's student welfare. There can be funds set up, for example, to finance. You hear these stories of families of Division I athletes who make it to, our spectacular spring fling, March Madness, whose parents can't afford to attend the game. I mean, a fund could be maintained to allow, family members to attend March Madness. There's all kinds of creative things you can do to deal with that problem of what do we do with the money once we win it. So we end up thinking, and both of us firmly believe this, which maybe goes against a bit of conventional wisdom, because a lot of people out there think that scholarship athletes it's a pretty good deal, and it probably is true. It is a pretty good deal. But I don't think that excuses what is a clear commercial exploitation of athletes. I'd love to have some questions. A couple of other notes I might make. These lawsuits are coming down the road, and uniformly, athletes are winning them. And I think what we're seeing is a gradual erosion of our amateurism model, not through reform internally coming from the NCAA, but through a gradual whittling away of this mythical notion of the amateur athlete through litigation. And there are one other lawsuit just got filed 2 weeks ago by the same law firm that's doing the O'Bannon Keller case, which would be a source of another good CLE maybe next year, where a scholarship athlete at Rice had gotten a full scholarship at Rice, great academic place, and played his freshman year football player, and got hurt. And his scholarship was terminated. Now, most people don't realize this, but the modern scholarship has morphed into a one-year renewable. It used to be, when I was a lad, it used to be somebody signed a 4-year deal. Well, somehow there's been this quiet change in the model, and the model now is basically a one-year renewable scholarship. And it's renewable pretty much at the option of the institution that grants it. And what's going on now is athletes can get cut because they're hurt, and the scholarship won't be renewed. Now, some schools choose not to do that because it's really bad practice, and it's a public relations nightmare for them to do that. But the fact of the matter is they have the right, under the scholarship agreement, not to renew a scholarship for whatever reason they want. And the second kind of abhorrent way of not renewing an athlete comes really with being cut for lack of skill. You know, an athlete is over-recruited, doesn't pan out quite the way the institution thinks, and at the end of the freshman year, there might be a coaching change, and they run the kid off. And running the kid off is really just not renewing the scholarship. Well, this Rice player, pretty smart kid, appealed it internally to Rice to get his scholarship renewed. And Rice was smart enough to give him another year. And then his third year, he was still hurt. He suffered a career-ending injury. He wanted to be renewed again, and they cut him off. And he subsequently graduated from Rice. And then I don't know who got to him or how he figured it out, but he thought, you know, I think I might have a lawsuit here. And the same firm that's representing O'Bannon has brought a lawsuit against the NCAA on an interesting theory, one that I'm thinking I might want to develop, and maybe we can do the same thing where you do all the work, you know. And this is the way we worked. He really did all the work, and then I kind of, you know, worked the deal. But the lawsuit, the theory on this lawsuit is that had he been operating in a free market, this high school, very talented high school football player, had the market not been artificially constrained by this collusive agreement among NCAA member schools, he would have had the leverage to negotiate for the traditional 4-year deal. So it's not an appropriation theory, but it's an antitrust theory based on an unreasonable restraint of trade, a collusive agreement among the member schools to restrain the ability of somebody to participate in the marketplace. And I think it's a beauty. So I'm looking forward to writing something about that one. My theory on all this is the NCAA is not going to reform itself. What's going to bring it down, well, I don't want to kill the goose that laid the golden egg either, because I mean I love sports. But what's going to bring it a little bit more under control, I think, will be litigation rather than reform. So I'm more than happy to open up. I can go on for hours with this. If some of you have to leave to get back to work or get back to class, feel free to do so. But I'm happy to stay around and answer questions and talk about this for as long as anybody is interested in doing so. Yeah.
When an athlete signs a scholarship contract, can you not subpoena that scholarship contract and look at it?
Oh, yeah. You can look at it. And
does it grant the school the right to use his or her name?
No. What I found is the scholarship agreement.
No, but I mean, my point is, let's take a public institution. I'm a graduate of the University of Texas. It's public. Can you not sue the University of Texas to disclose to turn over a scholarship contract?
Oh, yeah, it's not a disclosure problem. It's what's in the actual agreement. I mean,
what is in there? Nothing?
There's nothing that can, in my view, there's nothing that can arguably be construed as a willing, knowledgeable, informed consent. I guess I failed to say this. You know, running through the law of consent is the notion that for consent to be legally enforceable, it needs to be knowledgeable. You know, it's the notion of informed consent in tort law, that you need to know what it is you're consenting to and voluntarily agree to consent to it. And when something is foisted upon you through a contract of adhesion or through some kind of obscure document, the argument would be that consent is not legally enforceable. But I don't even think you need to go there in this case, because not only is it's not there. It's nowhere to be found. So it's not a matter of the documents not being available. It's that the documents don't support the theory of consent. Yeah.
The cover face in the NCAA basketball game, it was Griffin. Tim Tebow was on the football. They're compensated, right?
I don't think so.
Yeah.
On for EA Sports.
Usually they put those out after they've graduated.
Oh, okay, after they graduate.
So I'm assuming that they're compensated. They probably use them to promo the thing.
I guess the problem I have is I don't see the reason why compensation is barred prior to the time you've graduated.
Bringing that up,
yeah. And the pros, I was telling Sean this morning, I was talking about 4 or 5 years ago. There's a sports lawyers group of people who live in this little world that I'm in, and I see a lot of my friends out there who share this little world where sports, as Sean put it, sports and law intersect. And we were at a sports lawyers meeting where the head of the basketball players union was talking about the intellectual property rights of basketball players. This was 5 or 6 years ago. And they have a group licensing scheme where players agree to allow the NBA to use their names or likenesses in commercial ventures with the understanding that they'll get a piece of it. And he said he was glad to report to his union membership that he had just cut a check to every active member of a roster on an NBA team that year, and again, this was 5 or 6 years ago, of about $150,000 as their fair share of the marketing revenue coming from EA Sports games and replica jerseys and the like. Now, particular star athletes in the NBA, as I understand the system, they can opt out. In other words, if they don't think the group licensing scheme is going to serve them, if they're a star player and they think they can make more money on their own, they can opt out of the group licensing scheme. Some star players actually agree to be part of it, kind of as a public service to the more marginal players. Believe it or not. I mean, some players are making so much money. Michael Jordan, for example, late in his career, agreed to be part of the group licensing scheme, knowing that he was generating far more money than everybody else, but it didn't really bother him for him to be the impetus for the group licensing scheme to make more money, and then it's fairly distributed among the
On one of the MLB games, I think Barry Bonds opted out.
Yeah.
And my son had that, and we had to manipulate the game.
Right.
There was a player that was Barry Bonds, but he was right-handed and white. So we
but he had the statistical accomplishments of
John
Bonds.
Dowd, the guy said.
Was he big-headed or?
Yeah.
No.
He just manipulated it, did some changes.
Yeah.
He had the same number, I think.
Yeah. Well, I find this stuff endlessly fascinating, like I say, and I'm one of those people who likes litigation. You know, I hope most of you in here, lawyers, don't think of litigation as a dirty word, but I want to see litigation to destroy the BCS. I mean, I'm one of those guys who thinks that the antitrust lawsuit is waiting to happen, so I tend to root for teams who are in the best position to be good plaintiffs to take down the BCS, you know. So I'm a big TCU, a Boise State fan this year. Yeah.
Aware of any likeness case today that has been dismissed for the reason that the NCAA settled with confidential terms?
Yes. No, I'm not.
A
likeness case. No, there was another case where there was an NCAA settlement. Interesting you're saying that about confidential terms of a settlement, which is always something that, as a tort lawyer, bothers me when litigants enter into a confidential settlement that implicates public interest concerns. You know, a products liability case, for example, involves a plaintiff who's hurt and confidentially settles it, and the product's still out there possibly hurting people. But there was a confidential settlement in a case called White versus the NCAA. Very quiet. I would bet dollars to donuts very few people heard of this case, White, the White settlement. But a Pac-12 scholarship athlete brought an antitrust case against the NCAA on the theory that his scholarship was artificially limited to tuition, room, and board and books. And other academic scholarships included tuition, room, and board and books and stipends. And he argued on an antitrust theory that at least give me that. Why shouldn't I have the same economic clout as what other students can get? And the NCAA quietly settled that case for a significant amount of money. Again, I think with the same law firm that's kind of specializing this. And the case kind of went away, although if you're a member of the class of student athletes who were affected by the White settlement, their NCAA has subtly communicated with you, you're entitled to get a share of this money that you theoretically would have gotten had the NCAA not artificially constrained the market by preventing your school from giving you more than the traditional scholarship. So that's the only confidential settlement that I'm aware of. The other footnote on all this is the NCAA recently cleaned house and got rid of their whole legal staff. They got, they have made them so vulnerable with bad advice down through the years. They lost a $55 million case, an NCAA antitrust case called Law versus the NCAA. Law was a limited earnings case. The NCAA passed a rule that said you can only hire a fourth basketball coach and you can only pay him $12,000 a year and the value of graduate tuition. And the Duke coach at the time, one of the assistant Duke coaches, was getting about $100,000, and he was affected by this new legislation, and NCAA ended up paying $55 million. So again, I think they're vulnerable. I don't know whether their new legal staff, which is as yet not hired, will get out in front of these lawsuits or not. But that's what I kind of see coming to our neighborhood sometime soon. Yeah.
Wouldn't it serve their purpose, talking about getting out in front of it? Because I look at the NCAA now as being where Major League Baseball was in the mid-'60s when Marvin Miller took over the union and said, look, we just want some basic incremental changes.
Yeah.
Major League Baseball refused, and then Miller kept taking them to court, and finally the whole system collapsed.
Right.
And the players started, earning a lot of wages. You would think the NCAA would get out in front of this and say, let's make some incremental changes in, 4-year scholarships instead of 1-year scholarships.
You would think.
And instead, they're not really doing that.
Yeah,
They're just
I agree. I mean, I don't know. There's a fundamental inherent hypocrisy in the entire organizational structure that maybe prevents them from getting out in front of it, because they cling to this amateurism notion that we all also kind of cling to. We like the myth, the notion that our student athletes are really students and they're going to class like everyone else. So, we cling to that notion, and it sells. It sells. I mean, it's very appealing to people. So I think there's just this fundamental hypocrisy built into it that makes it very difficult for them to reform from within. One other thing I'm learning, as I'm in my little bubble world of sports and law, I've tried to learn what's going on internationally, because I feel like, okay, I kind of understand what's going on in this country. Internationally, there just isn't amateurism anymore. I mean, internationally, we're kind of the last bastion of amateurism, and it's kind of accidental that we built our system around, we built our big-time athletic system for young people around university life. It's kind of just an odd coupling in a way. And I think because we just accidentally developed that way, it's creating real tensions. And as a consequence, schools have to water down their curriculum to accommodate athletes that probably otherwise wouldn't have been in college, and then they can't pay them. And so, you see something like Cam Newton. When I see illegal benefits, I just kind of laugh. I kind of think illegal benefit, it's defined as illegal. It's an illegal benefit because the NCAA says it's an illegal benefit. But for, an underprivileged, incredibly talented athlete who sees the one-time ability to perhaps make some money, it's not all that surprising that what's an illegal benefit is viewed as I'm participating in the free market economy just like everyone else is. And in fact, in any other area but sport, do we do that to people? I mean, do we tell Justin Bieber? I guess I'm struggling now for a very current cultural icon. Do we tell him, well, no, you can't participate in the marketplace. We want you to be an amateur for a while before you. It doesn't make sense. Yeah.
You talked about the defense of consent. Is there any room to negotiate? Do you have the ability to do that?
You mean for the case to get settled?
Well, what I'm saying is, the athlete,
Oh,
senior high school,
great question. Great.
Senior high school
Yeah.
can assign
Great question.
a letter,
Great question.
and he said, look, you can't use my likeness,
I-
you can't do this, you can't do that.
I would like to see it. Now, the closest, that's a great question, because the closest I've come to seeing that happen is Xavier Henry, I think one of the Henrys, I think it was Xavier Henry, signed with Memphis when Calipari was there. And the dad was a savvy guy, comes from a very athletic family and had a lot of experience in professional sports. And he was afraid that Calipari would leave. Is that right? Was it Calipari? Sometimes I get some of those big name guys. Calipari, Patino, so, anyway. So this coach, this dad was pretty savvy. And what he said, and the standard agreement that you sign says you're agreeing to play for the school, and actually has a provision that says if the coach leaves, you're still obligated to play for the school. And if the coach leaves and you want to leave, you've got to sit out a year. Okay, so that's like an anti-transfer. But this dad was pretty savvy, and he anticipated the possibility Calipari would leave, and he negotiated out that provision that said, I'm signing with the school. He said, no, I'm signing with Calipari. Calipari leaves, I'm no longer obligated to attend Memphis. That's the closest I've seen to anybody smart enough, savvy enough, able to anticipate the problem, who was able to negotiate. So I guess theoretically you could negotiate a 4-year deal from your school with a termination provision, the way any other employee would negotiate provisions like that. Termination for cause, make it clear that if you get hurt, that they'll keep you on scholarship. If you're not as good as they think you are, they'll keep you on scholarship. So I guess my answer is yeah. I just think most student athletes aren't in a position, don't have the savvy representation and information to engage in that kind of thing. So, time to go? I'll be happy to, like I say, I can go on like this forever. So, why don't we take a break and see who needs to leave, and then people want to just talk, we can talk.